All right, it's 11 a.m., so let's get started. My name is Cindy Flynn. My firm is Hackler Flynn and Associates, and I have Angela Serranzana here with me today as well. You know, we feel like there is going to be a rise in employment lawsuits over the next 6 to 12 months, and maybe even the next few years. And so Angela and I are really here to protect and defend business owners in employment lawsuits. And we want to do everything we can today to protect us in the future. So with that being said, you know, I have a disclaimer because we are attorneys that content on this webinar should not be considered legal advice and is for informational purposes only. Communications made through this webinar and or participating in this webinar do not create an attorney-client relationship. This webinar is being recorded and you will be sent a recording once it's up and running. So just note that. And in addition, you know, we are not responsible for any content that you may access from third-party resources that may be accessed through or linked to this webinar.
Yeah, so some of the things that we're going to be talking about today are the laws that have been passed specifically to address COVID-19. These laws are very, very recent. Guidance is coming out every single day, sort of clarifying the intent and the applicability of these laws. So when we give you guys advice on those laws specifically, please understand that we are giving this advice based on our best understanding of these laws at this time. That might change. I know that in the first 2 weeks following the passage of the CARES Act, there was a lot of conflicting guidance coming out from a lot of different sources. So we have done our best to keep abreast of those pieces of guidance. And so, but understand that with any law, because it's new, the interpretation may change over time.
Thank you. So for today's topics, we have some updates on the PPP Loan Program. We have an expansion of unemployment benefits, how we safely bring back workers, independent contractors we're going to touch on just because it's still important. AB5 came out January 1st, and so if you have independent contractors, we're going to talk about them. And then we're also going to talk about your employees working remotely. So as the coronavirus outbreak continues to impact markets and industries in the United States and really around the world, you know, businesses are confronted with significant and unique challenges. Successful navigation of these challenges require thoughtful and comprehensive planning. The CARES Act, you know, affects both businesses and individuals, and many of these changes are aimed to help taxpayers conserve and generate cash. And so we're going to be going through that. When the CARES Act was originally signed into law in March, it provided the $2.2 trillion stimulus to individuals, businesses, and hospitals in response to economic distress caused by the coronavirus pandemic. It has since been expanded with additional funding. So part of the CARES Act includes a loan program for small businesses, and these loans can be forgiven through a process that incentivizes companies to retain employees. And as I mentioned, we're just going to focus on PPP, loan updates, and unemployment. Now, the Paycheck Protection Loan Program was originally funded with $350 billion, and then on April 24th, the government voted to add an additional $310 billion in loans. It covers the period of February 15th, 2020 through June 30th, 2020, and it greatly expands SBA loan eligibility. The loan program allows businesses suffering due to the coronavirus outbreak to borrow money for a variety of qualified costs related to employee compensation and benefits. Now, let's keep in mind that on an average year, the SBA does about 62,000 applications. Does anyone have any guesses on how many they've done in the last 8 weeks? It's over 5 million. So they've just been bombarded with trying to get their hands around it. And as of today, I've heard that there is still a $100 billion left in loans. So if you haven't applied for your PPP loan, please reach out to Angela and I. We can set you up with a banker who is doing them. And quite frankly, that goes really for any type of professional service firm or referral source that you need. Angela and I have a very wide network, and we are always happy to make referrals to other attorneys, to bankers, to CPAs, to anyone that we can offer, you know, some help with. So if you ever need anything, let us know. So Paycheck Protection Loan Program, what is a qualified cost? That includes payroll costs. And payroll costs are defined as wages, commissions, salary, or similar compensation to an employee. It includes payment of a cash tip or equivalent, payment for vacation, parental, family, medical, or sick leave. It allows for dismissal or separation, which I think is interesting to note. If you do need to separate from an employee, you can theoretically pay them a severance under this. It includes payment for group health benefits, including premiums. It includes payment of any type of retirement benefits and payment of state or local taxes assessed on the compensation of your employees. Now, this excludes compensation for your employees earning more than $100,000 a year annually. So it's capped at $100,000 a year. So that person who's on your payroll making, let's say, $120,000 a year, you can include compensation up to $100,000. And that number is, and Angela, maybe correct me if I'm wrong, but I think it's around $13,500. It's like $13,469, I want to say, that you can use for each employee. But don't quote me on that. I'm a lawyer, not an accountant.
Sorry,
Yeah,
Cindy,
go ahead.
if I can just jump in here. One of the questions that has come up for us is, for those employees who are making over 100,000, does that mean that you cap their benefits too? And the answer to that is no. We're just talking about the capping of the income at 100,000. You would just pay their full benefits like you would any other employee.
Yes, exactly. Thank you for clarifying that. That has definitely been a common question. And an easy way to think about it is anything that's included on your employee's paycheck stub would be included. Anything not included on your employee's paycheck stub would not be included. So for instance, your federal quarterly taxes, those are not included on a paycheck stub and therefore are not included in this. But Angela's absolutely right. Like the healthcare benefits and premiums that you're paying to keep those benefits in place for employees over 100,000 are included. And then what's also included are your mortgage interest obligations, rent, utilities, and interest on debt incurred before February 15th of 2020. So you can't go out, create a debt now, and try and sneak that in. Okay, so eligibility. You are eligible for a loan if you are a small business that employs 500 employees or less, or if your business is in an industry that has an employee-based size standard through the SBA that is higher than 500 employees. A common question we've been getting over the last several weeks is how to calculate the number of employees. It's either the average number of full-time equivalent employees of your company between February 15th, 2019 and June 20th, 2019, or it's the average number of full-time equivalent employees of your company between January 1st, 2020 and February 29th, 2020. Also, I think it's important to note that an employee who is working for you for 30 hours or more per week is considered full-time. I know there's been talk about how certain companies like Chick-fil-A, Ruth Chris, Shake Shack, how they've been getting funding. And there is, in addition to this, if you're a restaurant or a hotel or a business that falls within a certain classification system and each of your locations has 500 employees or less, you are then eligible. But as we've seen over the last couple of weeks, a lot of those companies are returning the funding. And then the two last things is, you have to be operational as of February 15th of 2020 and have employees.
So Cindy, if I can just jump in really quick here. A big question that we've been getting from a lot of people is, in order to maximize forgiveness, do we need to hire back the same employees that we laid off? Now, I will say this, the intent behind the CARES law is to make sure that you retain and maintain your employees, But from all of the guidance that I've looked at, they do not look into the individual identities of the employees. It's a straight FTE calculation. And as long as your FTE calculation is equal to the FTEs from one of the periods that you've selected, then you are maximizing loan forgiveness. So our understanding at this point in time, based on the guidance, is that you actually don't necessarily need to hire back the same employees. However, just know that that's just based on the guidance that we have currently. That may change.
Thank you, Angela. So the loan amount is limited to either 2.5 times the sum of your average monthly payroll cost or $10 million. And the amount is intended to cover 8 weeks of payroll expenses and any additional amounts for making payment towards debt obligations. And so this 8-week period may be applied to any time frame between February 15th, 2020 and June 30th, 2020. And, you know, if you are not able to get loan forgiveness, as Angela mentioned, it's still a very good bank rate interest loan. The interest rate is not to exceed 1%. It's for 2 years. There are no prepayment penalties or fees associated with this loan, and all payments are deferred for 6 months. Although I do want to note that interest does accrue over this period. So loans may be eligible for forgiveness on a tax-free basis. An eligible borrower of a covered loan guaranteed under the SBA is eligible for forgiveness if it includes payroll costs, and this includes employee salaries of up to an annual rate of $100,000, interest payments on covered mortgage payments, not principal payments, covered rent payments, and covered utility payments. The covered period means the 8-week period beginning on the SBA loan origination date. So taxpayers should note that the covered period, as currently stated, is for 8 weeks and not defined to match the loan term. If you would like to use the money that you get from the PPP program for other business-related expenses like inventory, you certainly can, but that portion of the loan will not be forgiven. Common questions we've been getting are whether or not you can prepay your employees. The answer is no. We do not recommend at all, under any circumstance, prepaying your employees. Another question we've been getting at this time is whether or not you can prepay rent. No, again, you do not want to prepay rent. It is for that 8-week period. Whatever you are doing, make sure you are keeping your banker and your CPA in the loop, along with your attorney. Now, Angela, I don't know if you've heard this, but there's been some discussion in extending that 8-week period to 12 weeks. And nothing has been signed, sealed, and delivered yet, but there is some talk about that. So you may want to just keep that in the back of your mind of, you know, in determining what's best for your business, I guess.
I currently have a question as to what's the origination date, the date you signed the acceptance or the day that you were funded. I'm going to take this as a question as to when the 8-week period starts. It starts on the day that you are funded, the date that the funds hit your bank. Yes,
exactly. I will say this though, however, also that, and there's no discussion, or they're in talks, but nothing has been signed, sealed, and delivered yet on this either. But if you are a business that has been forced to shut down and you haven't been able to reopen yet, they are talking about extending that date, instead of it being the date that the loan was funded, to the date that you are able to reopen. So keep that in mind. You know, things are changing on a very quick pace. And you're always welcome to email us. I mean, my email address is at the bottom of every single slide, or Angela's is very similar. It's angela@hacklerflynnlaw.com. We're trying to do everything we can to keep our business owners up to date. So if you want to get on our mailing list, you can just email us and I'll add you. And we don't spam, but we just want to keep you updated as things progress and as things unfold. Now, the purpose of the Paycheck Protection Program, as Angela stated, is to help you retain your employees at their current base pay. So if you keep all of your employees, the entirety of the loan should be forgiven. If you lay off your employees, the forgiveness is reduced by the % decrease in the number of employees. So if your total payroll expenses on workers making less than $100,000 annually decreases by more than 25%, loan forgiveness will be reduced by that same amount. Now, if you've already laid off some of your employees, you can still be forgiven for the full amount of your loan for your payroll costs if you rehire them by June 30th. And, you know, the whole purpose of this provision is to really encourage employers to rehire any employees who have already been laid off due to the pandemic. And borrowers that rehire workers previously laid off are not going to be penalized for having a reduced payroll at the beginning of the period. One thing I want to note here on that loan forgiveness and under payroll is whether or not you can bonus your employees. I mean, yes, you can always bonus your employees, but I don't know for sure if that would be considered forgiven under the PPP. Now, unless you can prove that for whatever reason, every May, every June, you give your whole staff a bonus and it's been done for years and years and years, then you have a higher likelihood of that bonus being forgiven. Another question we've been getting a lot of has to do with hazard pay. And I don't know if anyone else read this morning, but Amazon just took back the hazard pay or is planning on it, and employees are upset. And so in general, we don't recommend doing hazard pay just because with a pandemic, there's going to be no specific end date. It's not like we're at war and, you know, day 300 comes and the president declares that we're no longer at war. We wave the white flag. We're done. We're out of the war. In a pandemic with illness, there's no specific hardcore end date. And so we're not recommending our clients do hazard pay. I have seen something interesting where businesses that are open and need their employees to come to work still can do a hazard pay bonus. I'm not going to say that this will for sure be forgiven, but that's what we've seen. So maybe something to consider. Angela, I don't know if you have any thoughts on the hazard pay bonus, but kind of weary, and I don't recommend it for your stay-at-home remote office workers.
So with regard to hazard pay, I completely agree with you, Cindy. You know, you, as much as you want to be generous, you also don't want to put yourself in a position where you are paying out way more because this goes on longer than you thought it was going to. And you're going to make people very unhappy if you issue it now and then take it back later. In terms of whether or not bonuses are included under PPP forgiveness, right now I would say technically they should be, since that's what, based on an explicit reading of the text, because it does constitute compensation. However, that's a gray area that we have not gotten a definitive answer on yet. So I would just be really careful with bonuses, unless Cindy said, like Cindy said, this is something that you've done regularly for years.
And then one other thing I do want to note here on this is a creative way to fit more into your 8-week time period is to run an extra payroll. Again, do not prepay your employees for anything, but if your 8 weeks is going to run and you have your employees working for like 3 or 4 days in between the last payroll and when your 8 weeks runs, we think you can absolutely run an additional payroll early to cover that gap time. And then those other questions that are in the queue right now, we are certainly going to get to them. So just stay tuned. Okay. So to seek forgiveness, a borrower must submit documentation. It's really going to come back to documentation. And this is to encourage employers to rehire any employees who have been laid off due to COVID-19. And again, borrowers that had to lay off will not be penalized if they rehire by June 30th. As Angela said, it's really about headcount for your full-time employee. But I think in an abundance of caution, if you've laid somebody off, you want to offer them the job position back first at the same rate of pay and in the same job position that they were previously making so that you will not be penalized. An easy way to think about it, I think, is if you have an employee collecting unemployment as of June 30th, 2020, you're going to have a problem. You want to make sure that you don't have an employee collecting unemployment as of June 30th. And Yeah, updated guidance came out from the SBA. It was clarified that if you have an employee who has been furloughed or laid off and is offered to be rehired and then declines, that employee may be omitted from the loan forgiveness reduction calculation. However, we strongly recommend that you have this documentation in writing. So unemployment, you know, under the CARES Act, unemployment was expanded. It temporarily expands unemployment insurance for workers in a variety of ways, including you know, those that are furloughed or out of work because of COVID-19, those who are self-employed or gig workers, and then those who have exhausted state and federal unemployment benefit provisions. So the only individuals expressly excluded from coverage are those who have the ability to work remotely with pay, and those who are receiving paid sick leave or other paid benefits, even if otherwise they would satisfy the criteria for unemployment under the new law.
Cynthia, if I can
so qualifying, yeah,
so
please.
if I can just hop in on the last slide. One thing that you, and this has come up, you know, multiple times for us with our clients, if you have independent contractors that are applying for unemployment benefits, you need to, they need to be clear that they're applying as independent contractors, because the last thing that you want to do is have your independent contractors apply for unemployment benefits, list you as an employer, and trigger some sort of EDD audit for misclassification. So you need to maybe check in with them and say, hey, listen, if you are applying for unemployment, you need to remember that you're applying as an independent contractor and make it clear, because otherwise you may end up having an issue down the road. The other thing that I wanted to mention is, and this is a question that's come up, if you have people who are on, who you have workers where you've offered them their job back and they have refused because they're making more for unemployment than they would be normally, what you can advise them is that if you have work for them to do that's available and they turn you down, they are technically no longer eligible for unemployment, because there is work that is available to them and offered to them that they have now turned down.
Right, that's exactly right. And so how we are really telling our business owners in communicating with their employees is to let them know that unemployment is only for a specific period of time, right? And they may need to go back on unemployment if work dries up again. I mean, we don't know what's going to happen in the coming months. We don't know what's going to happen after second quarter earnings are going to come out. And if we see a crash, we may need to have those employees go back on unemployment. So I think it's really important that we determine that messaging clearly and letting employees know that this is what's best for them. And the reason why employees are now making more sometimes on unemployment than they were actually working for you is because of that additional $600 that came out from the federal government. So if you have an employee who's qualifying for $1 in unemployment, they are going to get an extra $600 from the federal government. These extra funds may be paid as a separate check or together with the traditional unemployment provided by the state. Additionally, recipients who were previously nearing the end of their unemployment can apply for an extension of 13 weeks with the state agency. However, the total benefit may not extend beyond 39 weeks in California. I mean, that's how long it took me to grow a baby. And so it's literally 9 months of unemployment insurance benefits. Okay, moving right along. With OSHA, as we are bringing our workforce back for businesses that have remained open because they are part of the critical sectors or for when the stay-at-home order is lifted in California, OSHA has promulgated guidelines which identify employee risk categories to assist employers in determining what safety precautions are necessary for their workforce. I really recommend each company go to OSHA.gov to find more information, because it's pretty complex. You know, there are 3 different risk categories. Healthcare workers and healthcare support staff are considered high risk categories. Employees with high frequency contact with the general public, such as school staff, those working in high volume retail, those working in high population density workplaces, Those constitute the medium exposure risk group. And then employees with minimum occupational contact with the general public and our coworkers, such as your office employees, remote workers, those constitute your lower risk exposure group. So when you assess the risk and determine next steps, there are specific employee categories that we're going to go over. Those employees who are returning from affected areas and those in close contact with those returning from affected areas. Now, those two groups are obviously not as important as they once were because of a bunch of travel bans, but we also want to get into those employees who test positive for COVID-19 and those showing signs or symptoms. And a couple weeks ago, Angela and I sent out a COVID-19, preparedness plan. If anyone didn't get a copy of that, please email it to me. We are happy to send it to you. As you reopen your doors, you are actually required to have a plan in place. And because COVID-19 is so contagious, it's probably not a matter of if someone tests positive, it's going to be a matter of when. So if you have employees returning from affected areas, and again, this isn't probably super important as of today's date, but those employees will be required to self-quarantine for 14 days. They may be required to undergo mandatory health screenings by the federal, state, and local authorities. And you want to follow CDC guidance for release to return to work for these employees. You want to maintain a very high level of alert. And very similar to those employees who have been in close contact with somebody returning from an affected area, they may be required to self-quarantine for that 14 days and also follow CDC guidelines. So employees who have tested positive for COVID, immediately send them home or have them remain at home. You immediately want to treat the affected area in which the employee worked per CDC recommendations. You want to advise employees and or customers who were in contact with affected employees, offer reimbursement for medical testing, file workers' compensation paperwork. We're going to get to that. There's a whole new presumption out there for us, and contact the CDC and local health department. It's important to note that you do not want to identify the employee by name. That needs to be kept confidential and as a need-to-know basis for any manager who needs to know, but keep that identity safe. Very similar to those employees who are showing signs or symptoms. You can send the employee home based upon observation of symptoms consistent with COVID-19. You want to follow CDC guidance for release to return to work for them. Immediately treat the affected areas in which the employee worked per CDC. And you may advise employees and or customers who were in contact with the affected employee. Again, you do not want to identify the employee by name, but you emphasize there's been no diagnosis, you're just acting in an abundance of caution.
Although these notifications might seem a little bit overzealous, I just want to note that the last thing that you want to do is to have an employee who is symptomatic have to go home, and if you don't tell people, you're going to have other employees. you are likely going to have other employees who are symptomatic or clients who are symptomatic, and you're going to have to go over the whole thing again. So we do recommend you acting in an abundance of caution and notifying people so that they can get tested, so that you don't have to go through the entire rigmarole again.
So in order to assess this risk, you can ask your employees to inform you if they have come into contact with someone diagnosed with COVID-19. You can ask them to inform you if they have any symptoms or have been diagnosed themselves. And you can also ask them to inform you of any recent travel to highly affected areas. What you may not do is target individual employees unless you have an objective basis for asking. So you had to have observed symptoms. We represent all business owners, and we had some very, very dear, caring business owners, send all of their employees over the age of 65 home. That is age discrimination. You cannot do that. That is targeting individual employees based on the basis of age and asking for an age discrimination lawsuit. So please do not do that. And you also do not want to ask about any other medical condition or medical disability information, anything like that. You still need to keep that confidential or not ask about it, really. Okay, here is the CDC's website. Follow the CDC recommendations. Basically, you want to ensure that all frequently touched surfaces are cleaned and disinfected throughout the day. This includes your tables, your doorknobs, your light switches, your countertops, your handles, your sinks, your phones, your keyboards, your toilets, your faucets, your sinks, all of these things. And err on the side of precaution when assessing the risk. CDC has provided an entire risk assessment guide on their website. And there's been some talk about taking the temperature of your employees. Historically, Angela and I have always said, do not do anything that could be considered a medical examination yourself. The EEOC has come out and issued guidance that says it's okay for employers to take the temperature of their employees. Honestly, though, if you're concerned about a particular employee displaying symptoms of COVID, send them home, advise them to consult with a doctor to receive medical clearance to return to work. So one quick thing about workers' compensation. On May 16th, just last week, California Governor Newsom issued an executive order creating a temporary workers' compensation presumption for employees diagnosed with COVID-19. The presumption is retroactive to the date of the stay-at-home order and will stay in effect for 60 days after its effective date. Therefore, the presumption is effective for employees working from March 19th, 2020 to July 5th, 2020. And under this executive order, any COVID-19 related illness shall be presumed to arise out of and in the course of employment for purposes of awarding workers' compensation if you meet these few things: that the employee tested positive for or was diagnosed with COVID-19 within 14 days after the employee worked for you at your discretion, the day that the employee performed work at the employer's place of employment was on or after March 19th, 2020, and the employee's place of employment was not the employee's home or residence. So essentially, the business that they went into. And lastly, the diagnosis was done by a physician licensed in California. So the presumption covers any employee who must work outside of their home during the stay-at-home order. While all essential workers were required to report to work are covered, the presumption also covers any non-essential workers who performed work at the employee's place of employment at the employer's discretion. So the presumption does not cover employees who went to work without the employer's direction. And this presumption is rebuttable. It may be controverted by other evidence, and the governor gave notice that the presumption could only be rebutted under strict criteria. The executive order does not limit the evidence that may be used to rebut the presumption. So keep that in mind. If there's any chance that an employee got COVID-19 by working for you, then you need to provide workers' compensation paperwork. Now, OSHA has a general duty clause, and this clause says that employers are to furnish to each employee an employment and place of employment that is free from recognized hazards that are causing or likely to cause death or serious physical harm. So a common question we've been getting is whether or not an employee can refuse to come to work. And the answer is only if they reasonably believe that they are in imminent danger. And OSHA actually defines imminent danger to include any conditions or practices in any place of employment which are such that a danger exists that can reasonably be expected to cause death or serious physical harm immediately or imminently. So that's really the only time. A common thing we've also been getting is, if we can, as business owners, require our employees to come back to work. If you're able to open up your doors and start back into business, then absolutely you can take those employees who are working from home and require them to come back in. Our thought, though, and our guidance is if we can socially distance, and keep your employees at home longer and it's not a burden, I've been recommending just continue to do so. But of course, if you need them to come back in, you can certainly require them to come back in.
The other thing that that's been coming up a lot is if you do have employees who are refusing to come in, not because of anything medically, not because of medical necessity or anything like that, what we're recommending that you do for now is to tell them, sure, if you want to stay home, you obviously won't be paid for it because it's not covered under the FFCRA, but at this point, I would say if you can just keep them on payroll and just tell them, listen, come back when you feel comfortable, I would do it, just because by firing them for refusing to come in because of a fear of COVID-19, I feel like you may be creating some liability with regard to retaliatory termination. So just be careful. If you can leave them on payroll and tell them to come back when they're ready to come back, then we would recommend that you do so.
Or have them take a leave of absence, an unpaid leave of absence. Okay, so, as Angela mentioned, with the PPP loan forgiveness, it's really about headcount. So, and if you offer the job back to somebody and they don't want to take it, you might be in the market for recruiting and hiring new employees. So there are many ways to advertise and recruit in your search for qualified candidates. You should avoid actions and language that could be interpreted as discriminatory or implying any long-term employment guarantees. In addition, you need to be very mindful about the bona fide occupational qualification, or BFQ. When advertising a position, consider whether it complies with all state and federal anti-discrimination laws and other laws related to rehiring. When drafting a job posting, avoid language indicating limitations or exclusions on the basis of any protected status, such as race, color, national origin, religion, sex, gender, gender identity, gender expression, pregnancy, age, marital status, veteran status, sexual orientation, or disability. We just had a client come to us the other day where they put the word young in their job advertisement. You really want to stay away from that. Instead of saying, I want someone young and energetic, use the term enthusiastic, right? Instead of saying perfect for a single person willing to travel, use travel is required, right? Like, let's stay away from anything that talks about that. And then you want to also stay away from any references that would contradict an at-will employment relationship. I mean, California is known for being an at-will state and it has that presumption. But if you say something like, we're seeking a long-term employee, or even looking for someone who can grow with the organization, those can certainly rebut an at-will relationship. And then on BSOQs, a bona fide occupational qualification is a characteristic trait that employers are allowed to consider when making hiring decisions, even though in other contexts, these characteristics would be considered discriminatory. For example, a religious school can require that teachers be members of the school's religion, but religion would not be a bona fide occupational qualification for an office manager in a dental office. So keep that in mind. And, if you want to run an advertisement through Angela and I, give it a quick look. We're happy to do that. Criminal background checks. So California law significantly restricts an employer's ability to use criminal background information to make a hiring decision. Employers with 5 or more employees are prohibited from asking about criminal history information on job applications and from inquiring about or considering criminal history at any time before a conditional offer of employment has been made. There are a couple exemptions. Most people do not fall under them. The easiest way to think about it is if you are a security guard company and you require your guards to be armed with guns, then of course, something like that you could ask ahead of time. But in general, you do not want to be asking about criminal background history on a job application. You want to get a conditional job offer of employment out there first. Okay, checking references. There isn't a specific law that requires you to check a candidate's references, but courts have held employers liable for negligent hiring for certain acts of their employees, which the employer knew or should have known. Reference checks are often part of the hiring process, but there are a couple things you want to look out for. If you intend to check a candidate's references, you should require the candidate to sign a waiver authorizing you to investigate all information that he or she submits on the job application. A common thing that comes up actually is where a candidate will get hired and then the business owner will not look into it for 6 months or a year when something doesn't seem right once the employee has started working, and that becomes a problem later on. So employment applications should definitely include that basic waiver allowing you to check past employment, personal references, and education. And you want to obtain authorization before you contact. When contacting these references, you must gain the maximum amount of information on a candidate without creating a liability for invasion of privacy. So stick to questions that are directly related to job performance, dates of employment, things like that. What you don't want to do, when checking prior employment references, do not seek information about the applicant's salary history with previous employers. This information is confidential. You cannot inquire about or consider the conviction history of an applicant, of course, until a conditional job offer of employment has been made. And then just be aware of the inadvertent violation of anti-discrimination laws. For example, asking about the marital status of a candidate or the number of kids that they have, or even the clubs or organizations that the candidate belongs to might indicate race, religion, national origin. Stick to questions regarding the job applicant's performance. So you may want to administer a variety of tests to all or some job candidates. When you can administer tests, it varies based on the attribute being tested. Tests must be job related and accurate predictors of success in the job for which the candidate is being considered. Employers may not implement tests that screen out or tend to screen out applicants with disabilities unless the job is related and consistent with business necessity. You may want to administer a variety of tests to job candidates. I kind of went through that. Okay. Consistency protects you. Basically, to ensure that the interviewees or interviewers conduct do not expose you to lawsuits, create a list of acceptable questions and stick to them. You can ask all of the questions on your list, but only those you feel pertain to a particular job. Be sure all questions are strictly job related, non-discriminatory, and not an invasion of the candidate's privacy. Avoid over-promising. Oral contracts can be created in job interviews when an applicant asks about job security. So you don't want to say something like, as long as you do a good job, you'll have a job. That may create an oral contract. And avoid any of these types of questions regarding race, religion, national origin, the whole list, social media accounts. Now, that isn't to say that you can't do a Google search on someone. That is public information, but you don't want to ask inappropriate questions. So something we always recommend is doing a Google search. Instead of asking, are you a U.S. citizen, ask if you're hired, can you verify eligibility to work in the United States? Instead of asking, do you own a car, ask, do you have transportation to get to work? You may be tempted to write on a candidate's application and or resume, and don't do this. Do it in a separate notebook. Unless you take complete legible notes that are not open to any misinterpretation and are no way discriminatory, just don't do it. An example is an employer made a notation on an application for a candidate for a position at the jewelry counter of a large department store. While he intended the notation to mean no experience selling jewelry, he wrote no Jew, and that resulted in a candidate filing a religious discrimination charge against the store. So just be careful of those abbreviations. Quickly, on independent contractor versus employee, just because someone wants to be an independent contractor doesn't make them an independent contractor in the legal sense. These terms are defined by law. And if you cannot circumvent them, and you cannot circumvent them by agreeing otherwise with your worker. So I can't even tell you, Angela, how many clients come to us and they say, well, this person wanted to be an independent contractor. It does not matter.
Yeah, this is a question that has come up a lot over the last couple of years. But basically people will say, well, they agreed to it in writing. They signed a contract that says they're an independent contractor. And at the end of the day, if you get audited by EDD or the Labor Commissioner or the Workers' Comp Appeals Board, they're not going to care about that contract. If the person is not truly an independent contractor, which Cindy's going to go over in a second, they will not care if you contracted for that privilege of calling them an independent contractor.
Right. We've seen people sue for misclassification, and that's what it is, a misclassification lawsuit. You know, I was an independent contractor, but I should have been an employee. We've seen people sue where they created their own independent contractor agreement, the independent contractor himself. And so it doesn't matter. It's a legal determination. And as Angela mentioned, you know, there have been some major developments in the legal landscape of independent contractors over the last few years. You know, January 1st, AB5 went into effect, which significantly altered the way California law distinguishes between employees and independent contractors. And that followed the 2018 California Supreme Court decision in Dynamex. It was literally 2 years ago. It was the end of April. And it set aside the longstanding common law classification standard focused on an entity's control over a worker and adopted a very rigid ABC test. So what is that ABC test? We'll get to it, but California law is definitely known to be one of the most rigorous in the country in terms of labor law. And I can't tell you how many employers that are out of state hire one person in California, and they don't realize that they've now opened themselves up to California law. Angela defended a company that was headquartered in Pennsylvania because he hired one person here in California and then got hit with a California lawsuit. So employers with employees in multiple states are strongly encouraged to identify all applicable laws in those states and consult experienced legal counsel prior to, you know, hiring or adopting or implementing new handbooks, anything like that. So using an accurately classified independent contractor can definitely relieve a lot of the burdens. For instance, with independent contractors, you don't have to have them on your workers' comp. They have no right to employee benefits. You don't have to take out taxes. A whole host of other things where you don't have to do. And it's so much easier to just 1099 someone at the end of the year. But there are risks, and we just want you to be very, very cautious of these risks. So Dynamex case came out where it said that every single person who works for you is presumed to be an employee. So it's an uphill battle to prove otherwise. And in order to prove otherwise, you have to show that the worker is free from the control, direction of the hiring entity in connection with the work performed, that the worker performs work that is outside the usual course of the hiring entity's business, and that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature of the work performed. So if the hiring entity fails to show that the individual worker satisfies all three of the criteria, the worker is an employee, not an independent contractor. And so
just really quick to sort of A prong and the C prong are the same as they've always been. That's always been part of the standard of assessing whether or not somebody is an independent contractor or an employee. What's really different here is the B prong, that the person is performing work that is outside the usual course of the hirer's business. The example that I give all the time is previously a clothing company might contract with a seamstress to create a particular piece of clothing. Prior to AB5 and Dynamex, that seamstress might actually be considered an independent contractor. However, after Dynamex and AB5, that seamstress will likely be found to be an employee because the service that she's providing, the creation of clothing, is work that is the usual course of the hirer's business. To contrast that, if you have a plumber who comes in to fix the toilet at the clothing store, that person is still properly an independent contractor because the plumber is providing a service that is not part of the usual course of the the clothing store's business.
Right. And so I think we're going to see a huge rise in misclassification lawsuits as well, honestly, because once, when you have those, independent contractors filing for unemployment right now, and then you see EDD audits, and then if they can make a couple extra dollars by filing a misclassification lawsuit in the future, they're going to have the option of doing that. Okay, there are some exemptions, however, and that's where AB5 comes into place. So certain professional service contracts are exempt from AB5, but that doesn't mean you're out of the gate, right? You're still looking at the Borrello test, which was the original test, or I guess the test before Dynamex came out. With all of these things, you want to make sure that the hiring entity can establish that the individual maintains a business location, has a business license, they can negotiate their own rate, their own hours, and customarily performs work for other people. And of course, it still relies on customarily and regularly exercises discretion and independent judgment in performing these services. Now, there are specific exempt occupations as well. Lawyers wrote the law, so of course we got in under the specific exempt occupations, but you still have to look at whether or not you fall under any of these occupations under Borrello. So there's also a business-to-business contracting exemption that states that the ABC test doesn't apply to a bona fide business-to-business relationship if the business is an entity formed as a sole proprietorship, a partnership, an LLC, and they contract to provide services to another business. But you still want to look at Borrello. But so before you get to Borrello, though, you look at the business to business, and you have to meet all 12 of these conditions in order to properly qualify as an exemption under AB5. So I'm not going to spend time going through each one of these. If you have questions, we're happy to send you the slides. But if you meet all 12, then you apply Borrello. So that's the step-by-step process. And Borrello really comes down to the right to control. These are the Borrello factors, and the difference between this and the ABC test, because a lot of things do overlap, the ABC test requires all 3 of the conditions to be met. Under Borrello, it's really considering and weighing the factors, making it more flexible and less demanding than Dynamex. A couple best practices: just assume all your people are employees unless they clearly meet all legal requirements. Consultation with legal counsel is definitely warranted. The couple $1,000s you spend today can save you hundreds of thousands of dollars later on if you're faced with a class action lawsuit. One thing Angela and I always hear is, well, my employees are like my family, they're like my friends, but we've seen the best man at a wedding, Sue. We've seen an employee who's worked for a company for 25 years, Sue. So we just want to make sure that you're as protected as possible. And then another thing is, when hiring an independent contractor, properly report the engagement to EDD. So the law requires a report from anyone who's doing business in California or deriving trade or business income from sources within California. And when you have employees working remotely, we think that it's very important to have a written agreement with them. It lays out the expectations, the start time, the end time, being available and responsive throughout the day. If you have anyone working remotely and they are a non-exempt employee, have them keep track of their time worked as well as meal periods and rest periods. This is going to be another area in which businesses are really going to be sued in the next few months. Angela and I just saw a client this week where they have an email from an employee that says, I've been having to work through my lunch. I'm too busy to take a lunch break. I'm too busy to take meal breaks. Well, if an employee is saying that, they are starting to keep track of their missed meal periods and rest breaks, whether or not it's true. They're working from home. It's your word versus theirs. You have to write them up and you have to pay them that penalty. And that penalty is equivalent to 1 hour of pay for each meal period missed, each rest break missed. It caps out at 2 per day, but something to keep up with. Another thing, if you have employees working remotely, you want to reimburse them for expenses. This includes internet and cell phone. So please make sure you are reimbursing their expenses. It doesn't matter if they've already had an internet usage at home. It doesn't matter if they've already had a cell phone that they've been paying for. You need to reimburse them a reasonable amount. There's no set amount, but make sure that you do that. So no matter who you use as an employment attorney, whether it's us or anyone else, please make sure you are keeping them up to date with what you are doing today with COVID-19. We don't want you to do something that could potentially get you sued a year from now. But in general, have your employee handbook updated once a year, check in with them twice a year. California raises the minimum wage every January. LA raises it every July just to keep you on your toes. So check in with them regularly. Something Angela and I developed is a playbook on how to reopen your business. If you haven't gotten that from us, please email me. I'm happy to send it out. It includes an addendum that you can add to your employee handbook at the end of it. And then no matter who you're using, make sure you have an experienced team of attorneys behind you. Every attorney who works with me has 12 to 20 years of experience. And something we do early on is a liability assessment, because it's always that employee who asks for their paycheck up front, or always comes in late but you don't say anything. It's those type of people who kind of see some red flags, but you find it too hard to just get rid of them. It's those employees you want to be on the lookout for, and we can help you through any of that. We have an employment compliance checklist I'm happy to send out as well. It has a list of 19 things you want to make sure you're doing as an employer. And for that checklist, you can text HF Law to 66866. We'll give you a copy of that checklist. We'll also get you on our mailing list. I promise you, we do not spam anyone, but when the Department of Labor comes out with a new poster, we want to make sure all of our clients and friends know about it. So we send that to you so that you can email it to your remote staff, so that you can print it and post it in your break room. Although we don't really recommend you posting stuff in your break room, because that just gives people an opportunity to sit down, eat lunch, and read how to sue you. Put it in the hallway. And then we are open for any other questions. I think we got through all of the questions today. We want to thank you guys for being here. Angela, any last minute words to wrap up?
Nope. Thanks, everybody.
Okay, perfect. It's exactly 12. Thank you all, and we are happy to answer anything. You can always email us. All right. Thank you. Take care.
Thanks, everyone.